So what are autonomous vehicle systems? Well, autonomous vehicles, or otherwise known as self-driving cars, are motor vehicles where driver decision-making has been augmented or replaced by intelligent systems. Often when discussing this emerging technology, the primary issue of concern is the impact a departure from human responsibility will have on law. However, not all autonomous vehicles are fully self-driving robots, negating the need for human intervention. To start off, there are 5 varying levels of automation. As you can see here, the higher the level, the greater the autonomy of the vehicle's intelligent driving system. For the purpose of centering in on specifically high automated vehicles, level 3 and 4 will be the focus of this video's discussion. So say currently or in the near future you decide to purchase a level 3 or level 4 fully autonomous self-driving car. Underneath all that excitement of owning and in a sense driving in the front seat of a seemingly futuristic car, it is important for you to comprehend who has the legal responsibility should an accident occur. Of course, this is not the first thing that comes to mind for those of you who are watching out of an interest to consider purchasing this remarkable technology. But nonetheless, the legal implications of possible damages or injury in the civil and criminal liability sense is crucial. In fact, this concern is important and must be addressed by government in order to take a step into the future where AVs have largely integrated into Australia's transport network. Now, in returning to the question of who will be liable, it is first necessary to address the definitional hurdles from Australia's state road laws. It is true that road rules are largely harmonised across all states of the nation. But to illustrate the hurdles, let's focus on only New South Wales laws. So Rule 16 of the New South Wales Road Rules 2014 legislation defines a driver as the person who is driving a vehicle, and the act of driving being one that is in control of. The case of Tink and Francis suggests this control is over the propulsive force of the car. The New South Wales Acts Interpretation Act, it recognises a person to be an individual, corporation, or politic. You might ask, why is all this relevant to liability? But this simple truth is that intelligent autonomous driving systems do not fall within this definitional scope of driver. This largely unveils the inadequacy of the current road rules in addressing the emerging autonomous driving technology. Although levels 0 to 2 autonomous vehicles are arguably consistent with the human-centered road rules, levels 3 and 4 are left unregulated by the current legal framework. To demonstrate the gravity of this unregulated area, let's consider the example of a level 3 or level 4 autonomous vehicle in actual control entering an intersection that is blocked. Now, under Rule 128 of the New South Wales Road Rules, a driver must not enter an intersection if the driver cannot drive through the intersection because the intersection or a road beyond the intersection is blocked. This rule is clearly contravened. Indeed, the human sitting in the car was not in control of this movement. But because the law does not incorporate the intelligence system as a driver, civil liability will inaccurately be imposed on the human after all. Now, this occurrence is flawed and not a precise application of law at all. To briefly touch on another area of civil liability, the rules on distraction leading to negligence or recklessness while driving are also inconsistent with AVs. The use of CITS, or for lay terms vehicle intelligence systems, demand the person in an automated car to interact more with their dash screens. This is a reality, and for those of you who have tested Tesla's Level 4 autopilot feature, you may be aware of the tendency to interact with the screen's dashboard for route tracking and even for playing digital games. But under Rule 299 of the New South Wales Road Rules, such activities concerning interaction with visual display units are condemned. Palpably, these shortcomings in the civil liability framework can be addressed by legislative amendments catering to the natural uses associated with autonomous vehicle users. In the criminal liability sphere, there is also the same uncertainty in understanding if an AV system is a person. Offences are inclined towards the conduct of natural persons, But the types of driver-related conduct that attract criminal liability are instances such as road rage, intoxicated driving, hit and run, and speeding. Palpably, the automated system would already be encoded with legal conduct that refrain from such human-natured instances. Rather, it is more likely that issues of malfunctions, bugs, failure of backup systems, or false sensor readings will be relevant to AVs. The New South Wales Crimes Act focuses much upon the operation of the vehicle and who was in charge of it at the time of conduct. Interpreting a case where one intoxicated person has entered into a Level 4 AV and subsequently caused injury to a pedestrian presents challenges for who is liable. This scenario first evidences the video's primary focus, shifting liability to manufacturers. Now firstly, the manufacturer or associated supervisors of the hardware and system of the AV product can avoid liability in this instance. They can rely on broad interpretations of being in charge that dictate its meaning to include the act of putting the vehicle in motion. Hence, the intoxicated person engaging the vehicle's autonomous system and making the car start moving should be liable. This somewhat aligns with the Californian case. When responding to a drunk driver sleeping in their self-driving car, Tesla emphasized an onus on occupants to not use autopilot when intoxicated, but to rather be attentive when using it. Although this case led to no injury, the company recognized the need to share responsibility between manufacturer and user. The intoxicated person in this scenario equally has access to criminal defense of having no intention to injure or not reasonably foreseeing that their car would hit a passenger. This argument in such a scenario would then likely shift liability to manufacturers. Ultimately, the question of who is criminally liable in such situations is highly dependent on the circumstance. The New South Wales law already can impose penalties and sentences on corporations, but it must adapt to the possible malfunctioning of artificial intelligence systems that may create novel circumstances requiring new offences. So given there is uncertainty over who is liable in a given circumstance, it is worthy to see possible options or tools that may alleviate this. The National Transport Commission recognises that attaining a complete legal framework that has caught up with this emerging technology will be a gradual development. One thing remains true, and that is that automated cars are statistically at least as safe as human-driven cars, perhaps even more so, as it eliminates the primary human-related causes of road accidents. This enough may attract the highly valuable role of insurers. They are a necessary ingredient in the wide adoption of AVs in that they act as an intermediary that protects for a system in which manufacturers are not overexposed to liability. Insurers serve both users and manufacturers, with users particularly being served with an option to obtain partial or whole compensation. Certainly, insurers have an interest in reducing accidents and also tapping into the growing AV consumer market. In most countries, the driver or holder of a vehicle that takes part in traffic is under a duty to insure for liability or the costs of accidents. Extending this scheme to AVs in Australia is a valuable suggestion for boosting confidence to innovate for manufacturers and purchasing for users, such as you, the viewers of this video, who are concerned about compensation and liability mechanisms. Certainly, the manufacturer's duty to get insurance has also been the backbone of successful US projects such as Google's Waymo. The National Transport Commission and several scholars have highly recommended the use of data recorders that should be installed in AVs and be an extension of manufacturers' monitoring system mechanisms for their products. Data recorders will allow the provision of evidential information on what factors contributed to a given road accident. That is, it will provide insight on whether the control of the vehicle was in the hands of the human occupant or as a result of an artificially intelligent decision. Clearly, this evidence will be critical for judicial interpretations of who is at fault. A requirement to have data recorders, or black boxes as they call it, is found in Germany's new law that also acknowledges AVs. Interestingly, manufacturers are already open to accepting liability, with Anders Carberg, Vice President of Government Affairs at Volvo Car Corporation, affirming on the greater responsibility companies should have for their product. The existing product liability legal framework already addresses the role of manufacturers in providing product safety. If these frameworks were to expand in addressing AVs, parties can directly claim compensation for injury or damage from AV manufacturers. The National Transport Commission has noted its support for this, finding that system, technical or mechanical errors could be addressed through expansions to the Australian consumer law. Indeed, reforms to product liability is a pragmatic and productive step towards reconciling the issue of liability in Australia. While this video's analysis may have hopefully hinted a future of manufacturers sharing or completely bearing liability, there are further nuanced conditions which present difficulty. It's not easy to answer who is the manufacturer that is legally liable. Tesla is a clear example of a manufacturer that develops their technology under a single house, but other manufacturers such as Fiat, Chrysler, and Google Waymo partner with outside software vendors. Clearly, an accident that involves a vehicle and its software requires the determination of a defendant. But this can be difficult in cases where hardware, software, and vehicle developers are different entities. This then leads to the question of who is truly liable: the party associated with software, hardware, or the actual car company supervising the whole operation. Academics point to the likelihood of one manufacturing entity owning the vehicle software and perhaps users only being a customer who operate under a license. This is interesting and, of course, challenges the manufacturer and purchaser system of the current automobile market. But comprehending this possibility is important nonetheless. Now, although this may seem far-fetched, but there is a growing scholarly literature on a future where artificial agents may be able to qualify for independent legal personality based on the tasks they have to perform. The effect of this is that the AV intelligence system may be found liable for any malfunction or outcome that has caused damages to the occupants or the vehicle. The mechanism for providing compensation is to have a delegated body or authority that is legally responsible for the AI. Now, such a future inevitably depends on the legal framework already recognizing the performance competencies of the automated driving system. There must be a legally credible acceptance of the legal effect of the performed acts by the robot. Now, while this may be far from becoming a reality in the current uncertain climate surrounding liability, this video takes the opportunity to acknowledge this true possibility. And with that, I'd like to say thank you for watching.